Good morning, everyone. We'll wait just a minute or so to let other folks join. Okay, so our presentation this morning is about fair housing, which generally means anti-discrimination. We'll concentrate on rental housing in terms of examples, but as we start through this, you'll see it applies to other kinds of housing. I'm Valerie West. I'm an attorney at MidPenn Legal Services. Also with us today is Nick Matash, also an attorney at MidPenn Legal Services. He's the one who was the main presenter last week when we did this for Lebanon County. We publicized this fairly widely, but this particular session is sponsored by Schuylkill County and the city of Pottsville. A couple of some basic information. If you have a question, you can put that in chat, or there's also a Q&A. Okay, and we have someone using chat. Hey, Nick, can you keep an eye on chat and Q&A?
I will do that for you. I'll let you know if we get any questions.
Okay, sounds good. Next thing is to say, although Nick and I are both attorneys, what we're going to give you today is legal information. Legal advice would be applying the law to your specific facts, and it would create an attorney-client relationship. What we're doing today is more general. If you can, there'll be information at the end about applying for services from MidPenn Legal Services. But this session now is general information. Okay, so Nick, maybe you have to advance the slides because my taskbar covers up the button. Can you do it?
No, I'm not able to either.
Okay. I don't,
there we go.
Well,
Something's
all
happening.
right. Well, I guess using my scroll wheel also advances it. Okay, so there are a couple of sources of anti-discrimination law. This is going to concentrate on the Federal Fair Housing Act. It was enacted in the 1960s with a lot of other civil rights kind of enactments. So Title VII applying in the workplace, and the Fair Housing Act prohibiting discrimination in housing. Okay, so our main topics are going to be who's covered, what kinds of dwellings are covered, and what would constitute discrimination. So under the Fair Housing Act, race, color, national origin are all covered. And, you know, a lot of times those may overlap, but they were all named in particular so that, you know, some landlord couldn't say, well, it wasn't race discrimination. I did it because they're immigrants or something like that. Also covers religion. And then over time, sex was added, familial status, and disability. So there's a very broad definition of what can count as a dwelling. So both private rentals, public housing, subsidized housing. It also covers the real estate market, selling homes, selling land, and then things like group homes, boarding houses, nursing homes, even university dorms. So very broad view, but then there are some exceptions. So the federal law exempts sort of small mom and pop kind of rental operations. So if there are 4 or fewer units in a building and the owner lives in the building, that wouldn't be covered. However, in Pennsylvania, the state act is triggered when there are more than 2 units. So if there's an owner and 2 apartments, that particular building would be subject to Pennsylvania's Human Relation Act. There's also some minor exemptions with regard to home sales, a little special rule for religious organizations and private clubs where they can prefer their members, but they can't discriminate in who can be a member. And then finally, senior housing, if properly qualified as senior housing, can make exclusions based on familial status, which chiefly means no children. So besides the Fair Housing Act, there are a couple of other federal rules. One we'll talk about is specifically enacted by HUD. The Section 504 of the Rehab Act applies to recipients of federal funding, so would mean things like public housing. And the Rehab Act specifically protects against discrimination on the basis of disability. The Human Relations Act is the state equivalent of federal anti-discrimination. So the Human Relations Act covers discrimination in housing, but also in employment and public accommodations. So it kind of encompasses the Federal Fair Housing Act and the Civil Rights Acts. And then cities and municipalities, townships, counties can have their own laws. So I mentioned the Rehab Act, so that prohibits discrimination on the basis of disability, covers all of the HUD programs. And the idea is that a person with a disability should have equal opportunity to enjoy the benefit of the federal program's services. If an location is covered by Section 504, if there's federal funding involved in the disability area, it is easier to claim that the building owner should bear the financial responsibility for any modifications. So that's if there's federal funding involved, you may have a little bit more leverage in some areas. We talked about how discrimination on the basis of sex is one of the protected classes. Also, for places that get federal funding, the Housing and Urban Development Department has expanded that so that it includes perceived sexual orientation, so being lesbian or gay or transgendered, gender identity, which could include transgendered or someone who says they're quote unquote non-binary. And it also includes marital status. And so that covers assisted housing, public housing, subsidized housing, both subsidies with vouchers or program-based Section 8 developments. And then also, if there's an FHA insured mortgage or financing is otherwise HUD insured. So extra coverage for sexual orientation, gender identity, pretty much. The state and local, right now, the Pennsylvania Human Relations Act includes that you cannot discriminate on the basis of age, and that is defined as above the age of 40. There's also some specific coverage for support animals, and then it gives tenants associated with individuals with disabilities. So perhaps the tenant doesn't have a disability, but the tenant's grandson, who often visits, is autistic and makes a lot of funny, loud noises. Well, that could be discrimination, and you could be fighting an eviction over his visits. So enforcing the Fair Housing Act, first, it's always better to try to get an agreement. If you take something to an administrative agency or a court, then you run the risk that, somebody else is making the decision. So if you could get an acceptable agreement, that's often the best approach. But so you can negotiate with a landlord. It can be a defense to an eviction action that the landlord starts, or there can be affirmative claims made, and there are different statutes of limitations. So to file a federal administrative complaint, you have a year. You've got 6 months from the time of the discriminatory act to file with the State Human Relations Commission. So if you want to complain about a violation of the Federal Housing Act, you go to the HUD Office of Fair Housing and Equal Opportunity. So I've got both the regular voice line and the relay line for deaf and hard of hearing. And there's also a complaint available online. For making a complaint to the State Human Relations Agency, you can call them. You can go to a regional office, and in Schuylkill County, that would be in Harrisburg. Or there's also a complaint form available online. So digging down a bit into the different protected categories, for race, color, and national origin, it's folks who are of a minority race or even perceived to be a minority race, or someone culturally who is from a country outside the US, or whose ancestors originated from outside the US. So discriminating against someone on the basis of being Polish or German, that could be covered even though that person is a white person. And examples of discrimination are having different terms, lying about whether housing's available. And it's common to try to parse out this kind of discrimination to do what's called testing, where an enforcement agency would look at advertisements of apartments available for rent, send someone, probably white, or if they're testing gender discrimination, maybe send a male. But in any event, you have someone who is not in the protected class ask to see the unit. And if they're shown the unit and the landlord's willing to rent to them, then the assumption is that apartment should be generally available. Then they'll send in someone of a protected class. And if the landlord starts saying, well, you know, that was rented just before you called. Well, we know that's not true because somebody else was just offered the unit. So that's one way of proving this kind of discrimination. And then there's also, you know, maybe they would try to keep a minority from renting by charging higher rent, or in the home sale area, using different standards for a mortgage or different credit standards, those sorts of things. Religion protects both overt discrimination, no Jews allowed kind of idea, but also other actions that can really, that would burden the exercise of free religion. So limiting using a home or a location as a place of worship, excluding religious institutions from a particular geographic location. There is a limited exception if a religious organization is operating the housing. So they can give preference to persons of the same religion. But again, they cannot, who gets to choose that religion can't be limited.
Val, we have a question.
Okay, which is?
Are there any discrimination laws that cover those who were formerly incarcerated? And I think in the employment setting, the way it works is the EEOC has put out some guidance that where employers are making hiring decisions based heavily weighted on someone's criminal record, given that the criminality rates are higher in minority populations, like in the inner cities, that if an employer is basing their hiring decisions largely on criminal record status, that can, in some instances, be a form of discrimination if it's being applied in a way that excludes minorities.
It has a disproportionate impact,
right?
Because those with a history of incarceration are disproportionately minority.
Correct.
And that argument certainly could be applied in the housing area. And in particular, I mean, in the employment area, the more necessary such a rule is to the kind of employment. So a police force may be more likely to get away with saying having a criminal record is a bar than a business that does trash and recycling, something like that. So in the housing area, it would have a disproportionate impact to have such a rule. And I think it would be more difficult for the landlord or home seller to come up with a plausible reason for why that rule is necessary for its operations. So good question. So back to sex, gender, having an environment where someone is, a tenant is sexually harassed, or there are also can be a negative environment. Again, perhaps charging an unrealistic price or a different price just to limit who can get in there. So it's not, but it includes sexual harassment. It's not just saying something along the lines of no women. Now, this also has been extended since the Biden administration has come in to include sexual identity and sexual orientation and gender identity. What I talked about earlier was limited to developments that had federal funding. This is a newer way of looking at discrimination. There was a Supreme Court decision interpreting the meaning of sex discrimination in Title VII for employment. And that decision concluded that discrimination on the basis of gender identity or sexual orientation, those are also involve discrimination on the basis of sex. So sexual orientation and gender identity are prohibited under sex discrimination in employment. And after that Supreme Court decision, HUD was, and basically the same analysis can apply to sex in the Fair Housing Act. So HUD was instructed to come up with a policy, and in fact, they now say that discrimination on gender identity and sexual orientation are prohibited. So that has expanded the limited coverage earlier for projects that got federal funding. Now it encompasses any defendant that could be covered by the Fair Housing Act. Kind of went through that. Okay, so familial status. It means families with children. It also is extended to pregnant persons or people working on securing legal custody of children, even if they don't have the children yet. And you don't necessarily even need to be the parent or legal guardian. But as I said earlier, elderly developments can discriminate on the basis of children. So what could familial status be? Well, it could be saying families with children can only live on the first floor, so you don't disturb neighbors as much. It could be saying no children. It could be limiting the areas of a large development that they could live in, or trying to charge per person, which would discriminate against larger families because it's the same unit. There can be some limits based on the size of the place, and the rule of thumb is there can be 2 persons per bedroom. on to disability. So just like with race, color, and national origin, it's someone who is a member of that minority or perceived to be. Disability covers individuals who have physical or mental impairments that substantially limit one or more major life activities. And so, I mean, that's meant to draw some lines between folks who really can, they are a minority and need protection. So like someone with minor allergies might not be considered to have a disability. And then in terms of covered impairments, you don't necessarily have to have it as long as the bad actor perceives that you have it, or you have a record. And it's not just overt discrimination, but the idea is someone with a disability should have an equal opportunity to make use of the dwelling unit. So you can then make a request for a reasonable accommodation or a reasonable modification. So that could involve some simple things like grab bars in bathrooms. It could involve bigger things like putting a ramp in or maybe some sort of chairlift. And it covers modifications to rules and practices, not just physical changes. So this rule against discriminating on the basis of disability, which gives you the right to request a reasonable accommodation. The landlord can ask you to document that you have a disability that should be covered. And that could be a note from a doctor. It can be a note from some other kind of social service agency, but they can't ask for an explicit diagnosis. That would be protected health information. And if the housing provider is already aware that you have a disability and the need for the request is clear, then it would be a violation to ask for more information. So things that you can ask for, we already talked about some things like the ramp. You can perhaps, if there's a risk of someone with memory issues leaving a pot on a stove or a pan in the oven, perhaps a microwave could be the answer. You can have things like remove carpeting to assist with mobility, flashing lights for the hearing impaired, for a doorbell and smoke alarm. It can even be something as simple as for a tenant with some developmental disabilities saying, can you, housing management, anytime you give them something in writing, can you send a copy of it to this person's mother or close friend? There actually was a settlement recently where a public housing authority had agreed as a reasonable accommodation to send copies of correspondence to a third party. And for some reason, they didn't always follow that. So this disabled tenant missed the procedure for recertifying eligibility for the subsidy. So then they take the subsidy away and want to evict the person because they can't pay the full rent. Well, I mean, it's hard to imagine that it got that far, but HUD had to step in and say, that's disability discrimination. You agreed to send additional notices and you didn't. It could be things like a handicap parking space. It could be things like, Social Security disability checks often come on the 3rd of the month or the 5th of the month. So if the lease says the 1st, the accommodation would be allowing them to pay rent a little late. There can be instances in which the reasonable accommodation is raised, like not before the tenant moves in, but after there's been trouble and the landlord wants to evict because the tenant with some documented mental illness just isn't keeping the place clean, or that tenant doesn't sleep at night and makes noise at odd hours, or maybe even has episodes of screaming or something like that. Well, if there can be a plan in place that would help control or limit some of those behaviors, so getting medication changed or getting a system whereby some third party comes in to verify that they've taken their medication, or some services to help with housekeeping. You can make those kinds of proposals, and if it's likely to help control the behavior and is not something that is too costly for the landlord or would require too significant and burdensome a change to their regular operations, then that would be a reasonable accommodation. So that includes permitting an assistance animal.
Hey, Val, before we get,
yeah, go ahead.
A couple of questions. One question was whether these rules apply to rooming or boarding rooms.
Yes,
boarding houses,
do.
and they do. Now it gets tricky though when the Landlord Tenant Act applies or not. That's where it gets to be a little bit tricky. I know down here in the Harrisburg area we have some property managers and owners who are trying to skirt around the Landlord Tenant Act by having folks sign not leases but these agreements that say, I know I'm not a tenant and the Landlord Tenant Act doesn't apply to me. And so, there's some interesting areas they try to apply. Instead of the Landlord Tenant Act, they try to say that they're more like a hotel, and therefore the Hotel House Innkeepers Act should apply. But as far as the discrimination rules, they absolutely do apply to boarding and rooming houses. And then the other question was about, let me look at it here quick. A person saw an advertisement recently that was requiring a 1-month security deposit for each adult on a lease, and whether that's permitted.
I think that would not be permitted. So, and I guess, so the question then becomes, is that dwelling covered by the act? Is it, does it have, if the owner also lives there, then are there more than 4 units? Or going to the Human Relations Commission, more than 2 units?
Thank you.
Yeah. And just to sort of explain why what Nick said, the dispute about whether something's covered by the Landlord-Tenant Act involves then whether there needs to be a pre-eviction notice and whether an eviction case has to be filed before a magisterial district justice, or whether there can be a more simple process of changing the locks or changing the electronic access. So if they try to get around coverage of the Landlord-Tenant Act, what that means is you're not going to have the ability to raise your discrimination defense at an MDJ hearing. You may be out first and then complaining, which then puts more of a burden on the protected person. But back to the reasonable accommodation. It does not have to be in writing, although we certainly advise that it's best that it be in writing. It doesn't have to use the magic words, reasonable accommodation. Doesn't have to be on any particular form. You can make the request if you need it to be able to live in a unit at all while you're there. If while you're living there, there's a new rule. And as we discussed, potentially as an eviction defense, and if you lose, even then on appeal. And it could even be raised for the first time on appeal. All right. So you make your request. Under the law, the housing provider has to respond. If they don't respond, that itself can be a violation, and a denial without a reason, or without a legitimate reason, is also a violation. A landlord can, it's hard to explain, because ultimately, whether a landlord has to agree to a particular request for accommodation, it's fact-based. It depends on the landlord's resources. It depends on the expense required to meet the request, or if it would require a fundamental alteration of how the provider operates. Perhaps there is no parking at a particular location. So to ask or expect a landlord to go out and find and rent a close parking space, that might be too burdensome. Whereas if there's a whole parking lot, it's not burdensome to designate a handicap spot. If, and this, again, it's sort of just examples of burden. If a tenant is so off their meds, or, it's a situation that really can't be remedied, where there is direct threat to the health or safety of the neighboring tenants or the provider's staff. And that also can include not just health and physical safety, but property damage can also be a reason to say we just can't go this far in accommodating. But absent that serious burden, the accommodation should be made. So the whole idea is you really need to have a negotiation, try to offer alternatives, try to respond to concerns. And mentioned earlier that having an assist animal can be the basis of a reasonable accommodation request. Under the law, it's not a pet. So no pet policies don't mean that a landlord has a reason to deny a request for an assistance animal. You do have to show that there is a need. Doesn't have to be an actual certified service or assist dog, but some provider, psychologist, someone needs to show that you need the animal for a disability, whether it be physical or emotional. As part of it really not being a pet, they can't charge a pet deposit, can't charge a monthly pet fee, can't impose restrictions on the kind of animal. They can't say, well, cats are okay, dogs aren't. Can't put on a breed restriction. They can't say no pit bulls. And they can't limit the animal to your unit. You know, if you need the animal and you are permitted to be in the basement laundry room and be in the community room, then your animal's permitted there as well. So that's the end of the fair housing part of this, but since we had folks together, I also wanted to give some of the basic information about emergency rental assistance, ERAP. In Schuylkill County, there still is money available. The next slide will show where to go. Earlier rounds of funding really required that the landlord be willing to participate. That's not a requirement now. The agency in Schuylkill has given money to tenants when the landlord hasn't accepted it. I'm aware of a, so landlord really wants the person out, person goes, gets money for back rent, actually gets some money for rent going forward. Landlord doesn't want to agree. Landlord takes them to court, and landlord can't get the person evicted because at the DJ hearing, the person shows that they can become current in rent, and the DJ says you got to take it. So it really does work that the landlords don't have to participate, but you can get the money and stop the eviction. If the landlord gets money for not only the rent arrears, but say the following 3 months, landlord can't evict for unpaid rent. Potentially the landlord could evict for some sort of behavior. If it's a subsidized unit, the rental assistance will not cover the portion of the rent to be paid by the local housing agency, but it will cover the tenant's portion. And it also can't, you don't have to be behind on rent if you anticipate that you're soon to be having trouble. And it also can cover some moving expenses and security deposit if you've been evicted, don't want to stay where you're having this trouble with your landlord. You want to be able to start fresh, and you can use the assistance to move. Okay, so you do have to be have had a reduction in income. It doesn't actually have to be a new reduction. And the definition of low income is really pretty generous. So in Schuylkill County, you would go to Schuylkill Community Action. They have some information on their website, and there's a phone number, and SCA actually has like an administrative office and a service office. So for the rent assistance, you would go to the office on 2nd Street in Pottsville.
A couple of questions here, Val.
Okay, great.
One was whether the slides will be available. Are we able to share the PowerPoint?
Linda, Elise, well, I guess if you want to send an email to me, I
Elise
can
says she can
send.
do it. Yeah. Elise,
Okay,
I don't know how to
okay,
do
there
that.
we go.
And they're
Okay,
going to put it on, Karen said they're going to put it on the county website.
perfect.
Awesome.
Okay,
And then we had a question about ERAP and
okay.
what happens if the building becomes condemned, like for utility issues or other physical issues. So the question is there anything a tenant can do if their landlord receives their emergency rental assistance, but their building becomes condemned because the landlord doesn't pay the utility bills or there's another issue with the building itself?
That could be an affirmative case against the landlord to have those repairs made. You should definitely, let me go to, so here's how to get help from MidPenn. And in that kind of situation, you probably want to be calling MidPenn so we can fight with your landlord. So we have a main intake line, toll-free number that's staffed from 8:30 to 3:30 Monday to Friday, except for certain holidays. And you also can submit an application online at apply.midpenn.org. Are there
And
other questions?
one more question, Val. Can someone use ERAP if they want to move out of county?
I don't know the answer for sure, but I think it should be yes.
I think that's correct too. I remember Matt, I think, has used it for that purpose too. I think
Okay.
I've seen some of his files turn up that way.
And that again, no harm in asking. And if you're denied, consider contacting MidPenn.
And that concludes the questions.
Wonderful. Well, thank you for your attention. I hope you've learned something. And no harm in calling MidPenn. We can't handle everything. Some things we can only give advice, some things, I mean, just to give you an idea. Landlords need to be providing habitable units. So if you have a leaky roof, broken windows, no heat, those are certainly conditions where we would try to help you get the landlord to fix things. But if you call because the landlord hasn't changed some light bulbs or something like that, you're not likely to get an intake. So we do have some guidelines about how serious a problem is, but we always try to help if we can.
Hey, Val,
Yeah.
a question came in on the Q&A section.
Okay.
Can someone who is homeless and has no income apply for COVID rental assistance?
Okay. I think that you would need to have found, you can get money for security deposit and moving expenses, but it needs to be, they're not going to give you the money unless they know it will result in you being housed. So you would need to have a landlord willing to rent to you despite the fact that you've got no income. So that's going to be a hard road to get down, I'd say. Potentially, if you have a housing voucher, but vouchers don't include security deposit usually. So you need help, that kind of help. I think you should be able to get the assistance. But, like I said, they're not just going to give you money in the hopes that you will be able to find a place. You would, in a situation where you don't have an existing landlord, to even, I mean, for them to even know how much to give you, there needs to be a potential landlord, so they know what the monthly rent would be. So, any follow-up on that?
I think that's it.
All right. Well, again, like I said, thanks everyone. Have a good day.